All right, good morning. What I'd like to do for this week is to give you the background information you will need on the constitutionalism in the 17th century. I believe, I hope that you've been working in LUTs. And so three things that I want you to kind of be ready to do. This is, I think this is what we talked about in class, but I want to make sure, right? So in chapter 1 in Lutz is going to be talking about the problem of origins. And so have a sense of what that is. Hopefully we talked about that bit in class, and it'll come out in your papers a little bit. The second thing we need to do is to give a sense of how Lutz, in an Aristotelian fashion, is defining his terms. So especially constitution, know what that is in his frame, but then other ways of using words like covenant, compact, organic, be able to define those. And then the big idea here is, so what is it that Americans develop that's missing in the English experience? To what degree is American constitutionalism rooted in this Commonwealth tradition? All right, now, enough of that. Let's get straight to the lecture. We left off with Edward Coke. Note that it's pronounced C-O-O-K, Cook, not Coke. And you'll find me trip up all the time, right? So Coke had been the Chief Justice of the Court of Common Pleas and the Attorney General under Queen Elizabeth. His impact on British law would be significant even if it hadn't been for the crisis of royal absolutism in the 17th century. He argued as the Attorney General that the common law revealed a more fundamental law than you could get in courts of chancery or equity courts. That to the extent that there is a higher law, and Coke believed it, you would find it in the common law before you found it in statutory law, right? Because the common law could bind and limit what was possible for sovereign power to do, right? Now remember, this is England. So Coke's conception of sovereign power is going to be the state. This is before Hobbes, so he wouldn't have conceived it of the state as a leviathan, but that Parliament working together with the crown was really what was sovereign. The judges wouldn't have been a part of them. The judges are sort of an extension of the king's will, but pay attention here to the way in which the judiciary functions in this kind of constitutionalism of the common law. We see this in a really famous case that came before Coke in 1610, and it's frequently cited by the American founding fathers, Dr. Bonham's case. Dr. Bonham was a practicing physician who had been put in jail by the London College of Physicians for practicing without being properly qualified. Now, this is an age in which there was great need for medical practitioners in London because London was rapidly growing. And the College of Physicians was sort of trying to maintain an old-scale monopoly so that there really wouldn't be that many physicians in London. The physicians who were licensed would make a lot of money. And Justice Coke overturns previous authority and argues that the College of Physicians doesn't have the right to judge this man. Now, yes, they're qualified to make medical decisions, but essentially, that if this is true, they could put their own competitors in jail. This is the principle that John Locke would later adopt, that no person is a fit judge of their own cause, right? So Parliament in their statute has explicitly said the College of Physicians has the right to make these decisions. And Coke says that this violates the common law. Let me read you a passage from the decision, right? And it appears in our book that in many cases the common law will control acts of Parliament and sometimes adjudge them to be void, for then an act of Parliament is against common right and reason, or repugnant, or impossible to be performed. The common law will control it and adjudge such to be void. So think about what that means. A lot of scholars see that as the kind of the beginning of something that will develop in America to be judicial review, right? Pay attention. Is Coke saying, I'm more powerful than Parliament? I'm striking down Parliament's laws. No. He's simply saying that the common law points out to us that this law violates common right and reason. Any person who is imbued with these powers would recognize that it violates a transcendent principle of justice, so it needs to be struck down. And so that Cook is famous for giving to us in law this series of aphorisms, principles, which Parliament can't just regulate willingly. Right? So another principle from the common law is the phrase "a man's home is his castle," which means that private property is sacrosanct. Another principle that was invoked quite a bit in the last decade was the stand your ground principle about the right of self-defense, state of kind of every citizens of the king, subjects of the king have this right to self-defense. I'm especially interested, though, in Cook as an inspiration for America, right? So he's a major figure in English law, but there's a confrontation that takes place on November 10th in 1608 between the king and Cook that in many ways foreshadows the English Civil War and then the American Civil War. So we get this on page 36 of Corwin, and not everyone has this, and so I'm actually going to do something a little strange and just read this to you, right? On Sunday morning, November 10, 1608, Cook and all the judges of England and the barons of the Exchequer faced James I at Hampton Court, to confute the notion which had been put in him by the Archbishop Bancroft that, inasmuch as the judges were just his delegates, he was entitled to decide cases in his own person. The judges informed the king, Cook records, that no king after the conquest assumed himself to give any judgment in any case whatsoever which concerned the administration of justice in this realm, but these were solely determined in the courts of justice. So pause. Note there, you've got this confrontation. The church is telling the king, you are the head of the court. All of the justices serve at your pleasure. So that makes you the chief judge, and you can make legal rulings. Effectively, you are the head of meaning in the British Constitution. And the judges are essentially responding and saying, no, like this doesn't follow precedent. Kings have never done this, not since the Norman Conquest. And so there are questions of justice that need to be handled, and they need to be handled technically by people who have judicial reason, who have learned right reason. Like, no one with common sense can see this. You have to know the common law. So this is the sort of concept, right? So the king, to this, the king answered that he thought, quote, he thought the law was founded on reason, and that he and others had reason as well as judges. But Cook pointed out the fallacy of this view in the following words. True it was that God had endowed his majesty with excellent science and the endowments of nature, but his majesty was not learned in the laws of the realm of England, and the causes which concerned the life or inheritance or goods or fortunes of his subjects. They're not to be decided by natural reason, but by the artificial reason and judgment of the law, which law is an act which requires long study and experience before a man can attain to the cognizance of it, and that the law was the golden meat wand. It's an old Anglo-Saxon phrase. It just means yardstick. The law was the golden yardstick and measure to try the causes of the subject, which protected his majesty, peace and safety. The king, the report continues, was greatly offended, saying that then he should be under the law, which was treason to affirm, to which Cook responded, I told you I would do it. Cook responded in Bracton's words, quod rex non debet esse sub homine, sub sed Deo et lege. It's a seismic moment. That Bracton's phrase means the king is under no man, but under God and the law. So this is the principle of higher law. In many ways, this is what the English Civil War was about. This idea that the king, executive power, wasn't a judge and couldn't be a fit judge in its own cause. And so the courts could be specialized and could develop. So the idea of an independent judiciary, never established really in England, is something that Americans turn to, right? Now, how do Americans encounter Cook? Like, where do they learn about this big idea? Well, there are two kind of main sources. Cook wrote a treatise on an old English common law called Coke's Treatise on Lytton. And it was widely used as a textbook in American law school. Right? Both Lincoln and Jefferson got Coke's Lytton and used it to study law and to pass the bar. Right? Thomas Jefferson wrote, quote, "The somber Whig never had a more profound learning than the orthodox doctrine of British liberties." So for Americans in the 1770s, this idea that the king is under the law, British government should be limited. This is a core principle. And in some ways, this is what then the American Revolution is about. Is sovereign power limited by a higher law, or is it not? Right? And Coke gives us the expression of that. Now, this question of the battle between royal power and legal rights is larger than Coke himself, right? The crisis of Stuart power really goes all the way back to the Reformation. The Tudors, Henry VIII, Elizabeth, had centralized power in the crown. And because that crown then, as the head of the English church, had enormous power over the shape of religion in the Reformation, this became something that I think all of the different parties felt like they had to battle for, right? And there were these different factions in English Protestantism. There was an Anglo-Catholic faction, which wanted to maintain the sacraments, maintain all of the trappings of to traditional liturgical worship. Then there was a Puritan frame, which wanted to strip away everything from the church that wasn't specifically commanded in the Bible. This was Calvin's approach in Geneva, and so this was an attempt to make English Reformation Calvinist. When James I comes to power, I think it's 1603, he did a lot to try to make the Puritans happy. Like, he had the Bible translated into English in the King James Bible, or the authorized version. But gradually speaking, he tried to strengthen his own hands to give him maximum influence in British politics. He tried to purge the Church of Puritan reformers. He tried to weaken the common law and strengthen royal courts. When Coke pushes back against him, there's this apocryphal saying that when the king says that his reason was just as good as anyone's, all the judges actually threw themselves face down on the ground. And when Coke actually said Bracton's dicta, he was laying prostrate on the ground before him. There's a sense of which they were terrified and afraid. Coke then actually runs for parliament. He resigns his judgeship. He runs for parliament, begins to organize opposition there. Then opposition took the form of the Petition of Right. Right. Now, the Petition of Right takes place under James' son, Charles. And Charles was forced to sort of grant the petition, in which it set up the principle that taxes would be granted by the king. No, they'd be granted to the king. He would have the right to revenue. In exchange, he would give up the right to kind of raise forced loans from his subjects, or the rights to arbitrary arrest, which were seen as in violation of Magna Carta. James doesn't like this, and so in 1629 he suspends this. He suspends Parliament and begins this long period, almost a decade, I think over a decade in British politics, where he attempts to run England without the Parliament, of royalist rule, right? And this is the moment when all of the Puritans decide that they're getting out of England, and they come to Massachusetts and they set up a Puritanism, right? Now, this culminates in England in the English Civil Wars. Eventually, the king runs out of money. Scotland itself, remember, the Stuarts were originally Scottish kings who come to England, rises. James feels like he needs money to beat the Scots. Sorry, I get these guys confused. Charles II, you see his picture there up at the top. He needs money to beat and fight the Scots. And so he calls Parliament in, counting on English patriotism to kind of join with him against the Scots. And the English are actually not at all interested in this. And so in some ways they cooperate with the Scots. The Scots are actually at this point Presbyterian. Charles had attempted to impose the English prayer book and English centralization on Scotland, and that had gone over very, very poorly. So the English Civil War then kind of becomes this full-blown phenomenon. And it's about power. but it's also about different theories of constitutionalism. The royalism of the monarch had developed a sort of more French approach, following the theory of Jean Bodin. Um, Bodin had argued that sovereignty must be unitary and so all power must kind of focus in one place. And in France, that was Louis XIV. And in England, that should be the Stuart monarchs. Um, the leading theorist of this in England was a fellow by the name of Robert Filmer, who wrote Patriarcha, who argued that this actually derived, this power derived from tradition. This is the way things had always been since the Garden of Eden. It sort of derived from the Bible. From the right that parents had over their children was like the right that kings had over their children. Now today, when we talk about absolutism and sovereignty, we're wont to kind of focus on the theory of Thomas Hobbes, who wrote the Leviathan in 1851. But no, in 1851 is a sort of after the fact. Hobbes is trying to justify something that's actually happened, and Hobbes is giving us a secular theory of royal power, tremendously influential for the future, but not very influential in terms of 17th century royalism, right? And the Puritans, in contrast, began to argue something that we'll call a commonwealth tradition, right? And so Lutz is going to give us a really fine account of that, but of the importance of covenants and consent in deriving political power. That there was a distinction between the civil covenant on which government rested and the social covenant on which society rested, and churches were sort of in that space. So because you could get rid of a king without getting rid of the social covenant, without getting rid of all the churches, maybe you could have a political revolution without society becoming anarchy. And this is then what the Puritans attempted, right? Now, in the midst of this, another kind of radical wave of Puritanism generated, right? Kind of beyond centralizing Puritanism, not centralizing, beyond kind of the modest reforms of Puritanism, is something we'll call republicanism. That's a tradition that names you would find Harrington, Algernon Sidney, and above all, John Milton. And they became the leading kind of apologists for what happened. Charles was defeated in a battle between the kind of long-haired Cavaliers and the Puritan Roundheads. He was put on trial and executed in 1649. And then England was governed for about a decade by the Lord Protector, a centralized executive, Puritan Oliver Cromwell, briefly his son. Cromwell found himself in a very difficult position. The factions that had united to defeat the king, the Scots Presbyterians, the Puritan Congregationalists, many of the radicals, a few proto-Quakers, couldn't be united. And so Cromwell was forced to declare religious toleration. Cromwell actually had dreams of a republic, but he didn't see how such a thing could be made to work. So in 1660, on his death, and I think the brief reign of his son, they decide, England decides, Parliament decides, this is a mess. We're going to invite the Stuarts back. And so Charles II comes back. Charles II is the son, I think, of Charles I. He reigns in England for 25 years. He'd been raised in Paris, but he never forgets the Civil War. He never forgets how difficult things were. So he's careful to treat Parliament with respect. Sort of English constitutionalism in the aftermath of that was in which, the Charles comes back in, reestablishes the church, and passes an act of, but he does try to build an alliance of, nonconformists and Catholics. He, gradually speaking, as he's been on the power for, by the late 1670s, there's a recognition that the monarchy is going to centralize a little bit. When he dies, his brother James comes to power. James is in fact openly Catholic. Charles had been a secret Catholic. And openly Catholic king reigns for 8 years. Um, no, he had 3 years, right? In 1888, his Catholic wife bears a son, and he's baptized as Catholic, and England then goes into Parliament invites the Dutch king, or the Dutch leader, William of Orange, who is married to one of Charles's Protestant daughters, Queen Mary, to come and be the leaders of England. And when they arrive, they're uber Protestants. They have this Declaration of Right in which Parliament declares these are the rights of all English people. So this is sort of like a Declaration of Independence for England, but there's no independence. It's just the sweeping statement of all of the rights of English people. This is a moment now where Parliament is going to have the upper hand in future battles between the king. There's a sort of century-long struggle between the king and Parliament. And Parliament wins. Now, Parliament isn't totally sovereign, but part of Parliament now has this right of lawmaking power and right of taxation. And from the English point of view, Parliament is the guarantor of rights against the crown, which might be the biggest threat to liberty. So these two moments sort of become different inspirations for constitutionalism. I think American Puritans continue to take as their model Lord Coke and Cromwell, and the idea that it's the Commonwealth tradition that limits power and that limits come on the king from outside. And England in the 18th century was really much more influenced by the Glorious Revolution and the idea that rights come to us from Parliament. So is it possible that Parliament could ever really do anything against liberty? Pay attention to those two themes and follow them in your textbook, because that'll be a major theme for the course. All right. In 1701 then, they're forced to kind of deal with the question of succession. They recognize that after Queen Mary didn't have an heir, there's a sister named Queen Anne. Queen Anne didn't have an heir. And at that point, you have to go all of the way back to one of, I think, either James or Charles's older daughters, who'd married into the Bohemian electorate in the Holy Roman Empire. And the heir of that family was actually the elector of Hanover. This is called the Hanoverian succession. In 1701, they say, well, whenever Queen Anne dies, the elector of Hanover, a fellow by the name of Georg, will come to England and become king. Now that becomes George the First. George doesn't even speak English, and so he's an exceptionally weak English king. And this is really kind of what sets up parliamentary power in English history, right? Long-term consequences for the empire and for America, right? Let me talk about one more major kind of event in the 18th century, or the 17th century, I'm sorry. Natural rights theorizing was one of the main kind of products of this Calvinist Commonwealth legal revolution. We talked about these ideas of self-government. In England, you also saw a revolution of natural rights thinking. So when Cromwell and Althusius and Pufendorf and Grotius tried to come up with a doctrine of limitations on royal power, they liked this idea of limitations coming from outside the crown. They tended not to talk about the English common law, because these are all scholars from the continent where there was no English common law. So they developed the doctrine of natural rights. So go less into precedent to find limits on the royal power and draw more on things that we can determine with right reason. And it's this natural rights tradition that Locke draws on when he writes his second treatise of government. Locke, we could spend a long time, we could spend a whole class reading Locke. I'm not going to do it. I'm assuming that at some point you'll take a class with Mailander. He's our political philosopher. You'll get a serious treatment of Locke. The main idea that you get from Locke's second treatise on government is this idea that people possess rights in the state of nature, that government is created to protect these rights, and when government abuses these rights, people have this right of revolution going against those natural rights. So that government exists to protect in Locke's phrase, our life and our liberty and our property, right? And this is an age of science. Locke imagined what he's doing is a lot like what his friend Newton is doing in orbital mechanics, that there are these rules of motion and matter that could predict what will happen in the future. And Locke thinks that he's a psychologist of Newton level finesse. And so today, when we talk about natural rights and the natural rights tradition that's so influential in America, we generally see Locke as being sort of the father of liberalism, father of ideas of liberty. Okay. I bring all this up because Lutz wants to give us a different account. So when you read Lutz, pay a lot of attention. He's got a phrase where he says, okay, all of the ingredients of American constitutionalism are in place by, I think it's a really early date, 1641. And at this point, Locke is 9 years old. Pay close attention to that point in the argument. I want to draw your attention to it, right? So that Lutz wants to argue, America's not liberal from birth. America, there's something else that's in the American tradition, and it comes out of this English Commonwealth covenantal tradition. And these are the two sources I want to talk about this, right? Let me back up and talk about British constitutionalism briefly to kind of do a wrap up, right? So what ideas do we see if we analyze English constitutionalism? Well, we could talk about the forms, right? The formal structures. The form of the English Constitution was that Parliament and the King together made the sovereign, and that the ideal constitution would be balanced. This was the settlement really established by the Act of Settlement in 1701, right? The King would have power, but so would Parliament, and the interests of the common people and the aristocracy would be balanced. And that was that was the form of government. Descriptively, though, English constitutionalism has changed, right? There's a fundamental structure that captures the whole of England. But there's really, once you get to 1701, Parliament's really making its own rules for itself. And there's less focus on limitation. So what had been for Lord Coke, the fundamental aspect of British constitutionalism, rooted in this common law tradition, becomes abandoned really in England, right? And the second meaning of constitutionalism as kind of about maybe rights guarantees, which are given to us by the state, that really becomes more the meaning of constitution. There are these then different ideas about kind of what the purpose of constitution is, right? For the Americans, they would look a lot at the old guarantees of Magna Carta, of the Petition of Right against Charles in 1628, of the Declaration of Rights in 1680, things that protect us against the king. But the newer idea is the idea that Parliament protects us, which is very powerful in England, less powerful in the colonies, right? With that comes this idea that Parliament is supreme within the law. And the open question here, this is the question that Jefferson raises, what happens when they act against natural rights? What happens when they go to the place that Locke talks about? What should be the recourse, right? There are also kind of different discussions about what the end of government is, right? I think there is a rough consensus coming out of this century of civil war and upheaval that the fundamental rights of an English person were: 1, private property; 2, the right to be Protestant; 3, the liberty of persons or the freedom of individuals, rights of conscience in particular, but also the rights of the body, meaning the right of habeas corpus, which we'll talk about in the class. And then also this right to be, Locke is sort of this freedom of speech, this freedom of ideas, this right to be a Whig, the right to have opinions, the right to maybe dissent a little bit. And so England becomes a really different kind of place than the kind of place we'd see on the continent, right? Now, I've been going about 30 minutes, so I'm going to stop here. This is really all the extra lecturing I need to be doing this week. But bring your questions about this to our classes on Tuesday and on Thursday. And on Thursday also, I'll do a little bit of extra discussion on the Constitution of the British Empire and how does Britain take these Lockean principles and use them to actually run the empire. And that's going to create a whole host of problems, both for England and for British North America. Okay, I look forward to seeing you in class, live and in person, on Tuesday.